Welcome, everyone. Jody Millman is the author of the best-selling Seats New York Theater Guidebooks. Her debut thriller, The Midnight Call, received the 2020 Bronze Ippy Award for Suspense, the 2020 American Fiction Award for Legal Thriller, the 2021 Independent Press Award for Legal Thriller, was shortlisted for the Clue Award and designated as Best Police Procedural by shantyreviews.com. She is a New York attorney, book reviewer for booktrib.com, the co-host and co-producer of the popular podcast Backstage with the Bardavon, available on iTunes, iHeartMedia, Spotify, and Google, and a former adjunct professor at the University of Detroit Mercy Law School and Marist College. Jody lives with her family in the Hudson Valley, where she is at work on her next novel, due out in April 2022. Visit her at jodysusanmillman.com on Facebook or Instagram. Welcome, Jody.
Hi, how are you doing, Christina? Someone else wants to be admitted. Do you see that hit? Okay.
I'll keep an eye on that, and I'll leave it up to you.
Okay,
now.
I guess as co-host they keep popping up. So
yeah, I'll handle that though. Yeah.
Well, good afternoon, everybody. Thank you for joining. The page just went black. Do you see that, Christina? I have James Blackstone. I don't have you up there.
Oh, I just shut my video off so that people...
Oh, okay, terrific. Okay, what I'm going to do now, I'm going to share my screen and then we'll start with the program, okay? Sharing it. And what I'm going to do here is, gotta move me out of the way and we will present. There we go. Welcome to Writers Law School. And what we're going to do is I'm going to give my presentation, and if you have any questions, please put them in the chat. And then when we're done, we have plenty of time and I'll be able to answer questions. So like I said, welcome to Writers Law School. This is what we're going to cover today. Today we're going to cover intellectual property, copyright registration and case, fair use, public domain, business entities, and publishing law. So as you can see, we've got a lot to cover today. Now, what is intellectual property? Intellectual property is a catch-all phrase, which represents an invention or a creative work that's like a manuscript or a design or a play, which has been created by an author and inventor and is subject to government protection under the law. We have three different kinds of categories for intellectual property. We have copyrights, patents, and trademarks. And we're going to discuss each topic and what is the difference between each one. First, we're going to talk about copyright. And everybody's really familiar with that little C with the circle. That's called a copyright bug. And what that does is it protects original works of authorship. We have copyright protection. You see, we've got a list of things that are subject to copyright protection. We have literary works, films, musical works, sound recordings, broadcasts, painting, blogs, poems, you name it, anything artistic works, anything that has really been created, taken from the creative mind and put into a tangible expression is something that is subject to copyright. Now, we're talking about writing. So who is the copyright owner? The copyright owner in our particular instance is the author. That is the person who created the work, and generally they are the person who is the copyright owner, except if they're a work for hire, and we'll talk about that in a couple of minutes. I have to stress, that merely coming up with an idea does not make you an author. You have to take whatever creative outlet you have, put it into a tangible form, and then you will be considered the author. Another thing I'd like you to remember is that from the minute you put your fingers on the keyboard, you are the author and you are the copyright owner. And protection is automatic. You do not have to register a copyright in order to be a copyright owner. And I wanted to also mention that you see this slide. I recently took a course with the New York State Bar Association about copywriting comic books. So I will be using some of these slides in this presentation because they really are outstanding and they really drive the point home. So what are some of the key elements of copyright? Well, first of all, each copyright owner has the right to make, copy, and duplicate the work that they have created. Here we have a little copyright golem. So that whoever made this would be able to make copies of it either on paper or distribute it any way they want. Distribution, that's another thing that's covered by the copyright law. Public performance, if you have a play, if you have a poem, if you're reading a narrative from a book, you are entitled to give a public performance based upon the fact that you are the copyright owner of that work. You're also entitled to display it. You make a film, you can display your film. You're an artist, you can put it up in a gallery. That is one of the elementary rights of being a copyright owner, public display. And the last one is derivative works. What is a derivative work? A derivative work is the right to take your original idea, in this case, the copyright golem, and then go ahead and extract other branches of creativity from it. For example, with our golem, we can make a comic book, we can make a TV show or a movie, we can make a video game or a toy. Those are some examples of what you can do with a derivative right. Now, one thing that I have to stress, and I think I've kind of hinted at this already, is that you cannot copyright an idea. So to prove the point, let's talk about William Shakespeare's Romeo and Juliet. It features, as we know, two star-crossed lovers. Now, the basic idea of having two star-crossed lovers is not anything that is protected by copyright. It is the expression of that story, the star-crossed lover trope, that entitles you to copyright protection. For example, let's look at West Side Story. That is Leonard Bernstein's twist on the star-crossed lovers trope. We have Twilight, we have Outlander, Titanic. I could go on endlessly naming Now, one of the things about copyrights is it's really, really easy to create. Why is it easy to create? Because as I said, from the moment you put your fingers on the keyboard, it's automatic. You don't have to do anything. It lasts for the life of the writer or the artist plus 70 years. That is the term of your copyright. And as I said, no registration is required, but it's better if you do. And if you're going to register it, here is the website where you would go and do the registration procedure, www.copyright.gov. But I want to talk a little bit about some of the benefits of going ahead and registering your copyright. Well, first of all, when you register it, that is putting the public on notice that you recognize that you are the owner of that particular work. It's a legal evidence of ownership. And just merely having the certificate in itself indicates the validity of your claim against everyone else in the universe. Now, another thing that is really important is the fact that if you were to go ahead and have someone infringe your property, in other words, take it, either claim it as their own or use it without your permission. For example, let's pretend that you posted a photograph, a really clever photograph on Instagram or Facebook that you took, or a piece of artwork, and someone took a screenshot and then started spreading it around the internet. Okay, you would want to sue for damages and you would want to tell that person to stop doing it. Well, unless you have registered your copyright, you cannot bring an infringement action. And once you do register your copyright, it entitles you to additional damages, costs and fees, all kinds of benefits that you would not be entitled to if you did not register your copyright. Now, one of the things that very few people know about is that when the COVID relief bill came into effect last December of 2020, it turns out that sneaking inside that 5,900 page document was a new provision which expanded the rights under the copyright law. It's called the Copyright Alternative Small Claims Procedure. And let me back it up a little bit. If you were to go ahead and sue for infringement under the copyright statute, you would be required to go to federal court. You would have to pay fees in order to start your lawsuit. You would have to hire an attorney. There would be prolonged litigation, and it would be timely and costly, very, very expensive. Under this new case procedure, the Copyright Office is set up and is in the process of setting up a tribunal, which allows people who have claims of under $30,000 to make their presentation directly to this tribunal. I'm not sure whether there's a fee. If there's a fee, it's minimal. You don't need an attorney. Getting the rules and regulations. They just announced who the tribunal is going to be, so they're in the process of getting this up and running. And I predict it will be sometime in 2022 that you'll be able to make a claim to this new copyright tribunal under the case procedure. Now, as far as copyright registration goes, as I said, you would go to www.copyright.gov. Now, what is the cost for this procedure? For filing, it's $45. That's for one single application. Now, also this year, there's a new procedure that the Copyright Office created, and it allows for what's known as a group registration, which means if you're, let's say, a blogger, or you've written poems, or you're on the internet and you've written pieces that are between 50 words and 1,750 words, and you've published them on the internet within a 3-month period, you're entitled to put them all together into a group and do one large application, which will cover them all. And that is $65, which is very reasonable considering the coverage you're going to get. Now, the turnaround time can be a little slow right now, especially with what's going on with the pandemic. You have to be patient in waiting for your certificate. When you apply for copyright, there are also 2 ways to do it. One, you can send a hard copy of your application and your work into the Copyright Office. Alternatively, there are forms on the website which allow you to download and upload your work into their database. Now, when you do it that way, you get automatically a receipt. You're not going to get your nice little copyright certificate, but you're going to get a receipt showing the date that you've gone ahead and filed for your copyright application. I hope everybody's with me so far. Now, one thing that you should always do, whether or not you register, is you should put our little friend here, the copyright bug, on your work. And what I generally tell people is, you put this on the title page of your manuscript. If you were an artist, for example, a photographer, you would put it somewhere in your photograph. If you are a graphic artist or you're a painter, you could put it on the back of your canvas. But this is the correct form. C, copyright, the year 2021, and your name. So make note of that. That's something important for you to remember. Oops, wrong way, here we go. Now, what is a trademark? A trademark is a symbol that distinguishes a good or service in commerce. And if you look at my little collage here, I mean, we all know Pop-Tarts and we know Oreos and IBM and VW and DQ. Those are trademarks. They're not protected by the copyright Okay. As I said, I am a member of the Romance Writers of America. Because of the unique services that they offer to writers, they have contests, they have blogs, they have all kinds of educational programs, they have conferences. Because of the services that they're entitled to, they would be entitled to register their name as a trademark. And you see the designations. If you ever pick up a package, you would see one of those three on there. We have a registered trademark, we have an unregistered trademark, and we have a service mark. Now, what does a trademark protect? What does it include? Well, you can trademark characters, you can trademark the title of the series, distinctive logos, as we talked about a second ago, and distinctive costumes. One thing I have to tell you is you cannot trademark the title of your book. So for example, if you are Diana Gabaldon, you could not go ahead and trademark Outlander, but because she's written 9 books going on 10, she would be able to trademark the Outlander series. That's the distinction. You cannot do the title of a book, you can do the title of a series. Now, we're getting to the third area of our intellectual property. And what is that? That is called a patent. And this is as opposed to being a register, as opposed to being able to register an artistic work or a work that goes into the mercantile system. Patents are designated for works of scientific achievement. And also, the term of a patent is much more limited than that of a copyright. A copyright, as I mentioned, is the life of the author or the artist plus 70 years. A patent is for only 20 years. And that's why if you hear the news, well, there's a shift from this particular drug because it's going from being a name brand into a generic. That is because its patent has expired. It's no longer entitled to coverage under the US patent laws. Now, patents also apply only to the United States and the territories of the United States, where with copyrights are basically worldwide. The United States is part of a convention which allows protection of copyrights around the world, where, as I just said, patents are limited to the United States. Now, there are 3 different kinds of patents. The first is a utility patent, which is an article of manufacture, a machine, a process that's new and original or a useful improvement upon an existing machinery. Okay, let's say you have a typewriter and you've designed a new different type of mechanism for the typewriter. You would be entitled to a new patent. We have design patents, which takes an existing invention and then redesigns it. And the perfect example of here is the butter hub. And I had to laugh because the other day I was reading the Wednesday New York Times, and they have a food section, and they were talking about the butter hub. It's a different way of storing butter. It's got, if you look at the top, it's got a little knife that attaches magnetically. It's got little feet that hold the top of the butter dish in place. Can you see that? And when I looked at the package, it says patent pending. So it's kind of interesting that these people have gone ahead, recognize that they have something worth protecting, and they're going ahead and they're applying for patent protection. The third type of protection is for plants. So let's say you come up with a new, they call it asexual plant, that you've developed a new type of rose. You would be entitled to protection of your rose. So to quickly summarize, we have copyrights, which are for artistic works. We have trademarks, which are basically logos for objects and services which are in the mercantile system. And then finally, our intellectual property is patents, which is basically scientific works, designs, manufacturing, and plants. Now, most of us are most interested in copyright. So I'm going to go back to copyrights. Now, the question is, if you have a copyright and it expires, what happens? I'll tell you what happens. The work goes into the public domain. That means anyone can use your work without having to get your permission because the copyright has expired. Now, each January 1st is considered Public Domain Day, and that's because a new wave of works enter the public domain. This past January 1st, works produced in 1925 and before entered the public domain. And here are some examples. Now, every time I look at this, I'm shocked at the works that have entered the public domain. This year, The Great Gatsby, we had an Agatha Christie, we had Virginia Woolf, and George Orwell had a particularly bad year. He had two major works enter the public domain, his Animal Farm and his 1984. So what this means is if I wanted to write a play or I wanted to do a movie about these works or of these works or adapt them in any way, I would be able to do that without having to get permission from their estates or permission from whoever the copyright owner is for these particular works. Now, what does that mean? Free quotables. That means that anybody could take and make quotables from anything that's contained within a work that's in the public domain and not have to pay any kind of royalty. And for example, we have here, It's Better to Burn Out Than Fade Away from The Great Gatsby, and then Blowing in the Wind in 2020 went into the public domain. So somebody would be able to make a t-shirt that says, how many years can some people exist before they're allowed to be free? Now, the next question is, if a work is covered by copyright and the copyright has not expired, can other people use it? The answer is yes, for very limited, specific purposes. And what that is, it's called fair use. And generally it's for educational purposes and non-commercial purposes. Now, if a court were to examine what is a fair use, they would look at these 4 elements that are on the screen. Was it used for educational purposes, for news? Was it for criticism? Was it for parody? What is the nature of the copyright? Was it a creative work or was it a factual work? How much of that copywritten work was permitted to be used? It had to be a very small portion. Does it have any impact on the commercial viability of that particular work? Those are all the things the court would examine in determining whether something is subject to fair use. In brief, fair use can be claimed for news, criticism, and here's poor Charlie Brown, he's being used for parody. All those things tend to be fair use. Now let's look at some examples of fair use. And I always like looking at these because it allows people to use your work and again, create a new and distinct different work, which is kind of interesting. Here's Girl Talk. She was a DJ. What she did was she took snippets of other songs, mashed them up, and made her own song. She's entitled to do that because she used a little bit of those songs. She was not using, and it was, she created her own work out of that. The same thing for the guy who was watching copywritten video games and taped himself playing the games and having a good time. A prime example is also somebody like Ken Burns, who goes and takes archival footage and archival photographs, things that are in the public domain and some things that aren't, that are newsworthy, and then puts them together and makes a documentary. That's fair use. And finally, Shepard Fairey is a graphic artist. And his story is really kind of interesting because he's the guy that took the Obama made the Obama poster that says hope. Originally, the Associated Press ran that photograph on their service. It was created or taken by a part-timer named Manny Garcia. What Fairey side by side with the poster is exactly the same. You just changed the colors and added the word hope. Then Manny Garcia raised his hand and said, look, hey, I'm the photographer. I took this photograph. I'm entitled to get paid. Well, turns out that Manny was working for the Associated Press. That made him a work for hire. That made the photographer work for hire, so he had no claim. The Associated Press had a claim, and what they did was they ended up reaching an agreement with Ferry. Ferry said, okay, you're right, I concede. From now on, I'm going to license this image from you, and not only that, we will share any of my revenues 50-50. So those are some examples of how fair use can be used, and also how it can backfire if you're not super creative. Whoop. Now we're going to talk a little bit, and this is something that I'm sure is of interest to writers, defamation. Now, what is defamation? Defamation means that you say something bad about someone. You communicate it to a third person. Now, why should we know about that? Because first of all, we have two types of defamation. We have libel. Libel is when the defamation occurs in written form, like a magazine, an internet, a blog, an article. The intangible form is called slander. And I remember that because slander and S for spoken word. Examples are speech, a news broadcast. And here we have Sue the Lawyer, 1 to 3 p.m. Now, as writers, why are we concerned about that? Well, first of all, there's a case that's called New York Times versus Sullivan. And that case held that when you have a public official, they have a much stricter rule of proving defamation than the rest of us. They have to prove actual malice, that the words were said with the intention to harm, and that the words were false. Now here we have a billionaire space race. And let's say we're writing a book and we want to incorporate the figures of Jeff Bezos and Sir Richard Branson in our story. What I always tell people is that you cannot disclose anything that the general public does not know. If you know a secret about these people, you cannot go ahead and then public disclose it in your story, because that can be deemed to be malice. If you know something that can harm them and you disclose it, that can be deemed to be malice. What you have to do if you're writing about a public figure is you've got to go big or go home. You've got to make their characteristics so overblown in your story that no one would really believe that you're writing about Jeff Bezos or Sir Richard Branson. So to protect yourself, only disclose facts that are public knowledge, and also make sure that you create a fictional personality for that person. And a good example would be if you look at Paula McLean's story, The Paris Wife. She wrote about the first, I think it was the first wife of Hemingway, Hadley, and her relationship with Hemingway. In historical fiction, what she did was she twisted the reality. She made she named the characters after real people. But when you read the book, you have to wonder, were these people really like this, or did she fictionalize their entire personalities? That's what you have to do if you want to incorporate real people into your manuscript. Now, as writers, we are in the business of writing. So I'm quickly going to go over the different kinds of businesses and what you can do to protect yourself. Well, naturally, we have an individual. That would be just Jody Millman writing as Jody Millman. If I wanted to write Jody Millman as, let's say, Butterfly Enterprises, I would have to file what's known as a certificate of doing business with the county clerk. It's a fairly inexpensive process, maybe $30, $40, that allows you to use an assumed name. But because you've used an assumed name, that does not shelter you from any liability. That's the same thing. It's just an AKA, also known as. In order to receive any kind of protection and create a shelter, That would be a limited liability company. That's an LLC. I would become the general manager. And as a result, all of my assets would be protected in the event that I'm sued for defamation. Let's just say, use that as an example. That's a shelter. What you do is you would go to the New York State Department of State and you would file your certificate of LLC. With an LLC, there are certain publication requirements. Well, I don't know if you pick up your newspaper. If you turn to the back where they have the classified ads, you'll probably see these tiny little ads indicating that so-and-so has started an LLC. That's one of the requirements, that you have to publish your notice. Corporations are also created by filing a certificate of incorporation with the Department of State. It's a much more complicated process. I would suggest that you have a service do it or that you have an attorney do it, because there are things that involve shares, shareholders agreements, notices of meetings, all of those things which are technical requirements to be recognized as a corporation under the eyes of the law and also under the eyes of the IRS. Again, there are different kinds of corporations. A nonprofit is called a 501c3. A regular corporation is called a C corporation. A subchapter S corporation is one that's a designation that you make so that all of the income and all of your loss flows to you individually. You still have that protection, but you're not paying a corporate tax and then an individual tax on any income. It's a nice little slide that allows you to take care of tax advantages, which you should speak to your accountant about. Partnership is an agreement that you entered into with another person. Let's say you're co-writing a book. The two of you would come to some kind of agreement. You would put it in writing. It doesn't get registered anywhere, but it sets out the duties and obligations of the two of you should your partnership go awry. And I always tell people the reason why you enter into a partnership is to remain friends, so that each of you knows from the get-go, who's bearing the expenses, who's going to do the work. And so everybody knows what's going on. So in brief, those are the 4 different kinds of businesses which are available. As you can see, I created an LLC and I went through that filing process with the state and also the publication process. So again, in forming a corporation, why do we do it? Why do we form a company? Because we want to limit our liability. We want to protect our assets. And remember that all contracts you sign must be in the name of the company. And again, an LLC, like a corporation, have to be filed with your state. In New York, it's the New York State Department of State. Connecticut, it would be the Connecticut Department of State. Now, this is something I know you've all been waiting for. We're going to spend a little bit of time talking about publishing contracts. And this is it could be with a traditional publisher, could be with an indie publisher. But these are some of the things I want you to think about when you enter into a publishing agreement. Well, first of all, congratulations if you get offered one, because it's really a momentous day in your life when you get the call or you get the email or you get the text saying, yes, we want your manuscript. But what does that mean? Well, that means it's an agreement that you're going to enter into with the publishing company that binds the two of you and sets up your relationship and what your duties and obligations are going forward in the project. It clarifies the terms and conditions, and it also provides ramifications in the event of a breach. Now, be forewarned, these contracts are generally drafted in favor of the publishing company. And what that means is that when you get it, most of the obligations are going to be for the author to produce, which is natural. You're the one that's providing your manuscript for publication. But there are things that can be negotiated, and we're going to talk a little bit about what the key terms of the contract and some of the major elements. First, we're going to talk about the work. What is the work that's going to be covered by this contract? Is it one book? Is it for the series of the books? Does your publishing company have a right of first refusal on your book? Does it also mean that if you write other books, but you've got the same characters in it, does your publishing company have first dibs on those books in the future? So what you have to think about here, what is your short-term goal And what is your long-term goal as an author? What kind of relationship are you having or going to have with this publishing company? Second, what are you granting them? Are you granting them TV rights? Are you granting them book club rights, foreign rights? What is the territory? Is it the world? Is it the United States? Is it only English-speaking countries? What are you granting them? Is it an exclusive agreement? Does that mean that you couldn't go ahead and write an article for Vanity Fair? Does that mean that if you want to write another book that has a children's book that has nothing to do with your thriller novel, are you bound to them? These are all of the things that you have to look at. What is granted to them? Next, manuscript delivery. What are the specific dates that the author must produce the product? Okay, when must you be ready to submit your finished product to your publisher? And also, not only is it just a product and a manuscript, it has to be a publishable manuscript. So that's another thing that's really, really important. Another thing is, also as far as delivery, have you built in any cushion? Suppose you find out that one of your kids is getting married or one of your kids is having a baby and you want to go and spend a month, but your manuscript is due. Have you built in a little bit of a cushion that allows you to say, hey, I've got a family situation, I need a little bit more time? That's something that you should think about putting in the contract. Another thing is, who owns the copyright? Generally, it's the author, not the publisher. And make sure that you as and again, this is a blinking light. You do not want the publisher owning this. The author is the person who should be, the author is the only person who has a claim on your material. Believe me, because eventually this contract may end. You don't want the publisher to have the copyright because then you have to go to them and they've got to transfer it back to you. And I can speak a little bit from personal experience about this because my first novel, The Midnight Call, was published in 3 forms: paperback, ebook, and audiobook. The audiobook itself was produced by my publishing company. What they did was they took my underlying work, they hired someone, she did the narration, and they went ahead and they published the book. Now, I've since moved on to a different company. They've agreed, and the old company has agreed to give me my audiobook back, but they're the ones who registered the P, which is the phonographic copyright. So now I'm in the process of negotiating with them to get that copyright back. So you don't want to find yourself in the position that I found myself in. So word of warning, own your copyright. Here are some other key provisions that I want you to keep in mind as well. How and when will publishing be taking place? As I said, I was published in softback, ebook, and audiobook. Are you going to be in hardback? You're going to want to know that. The payments and royalties, you're going to want to know about what are you getting paid. And what's interesting is that there's generally a sliding scale depending upon the type of format for your book. And I'm going to be discussing that in a second as we go forward, okay? As a matter of fact, let's do that now. And one thing that you should know is that generally when you receive a royalty, it's within 10 to 15% of the publisher's revenue. So that means if the publisher, generally let's say that right now, most publishing, if you are an indie publisher, is with a group called Ingram Spark. And what Ingram Spark does is they're the ones that go ahead, actually print up the book, and then they'll distribute it to the bookstores, to Target. They're the ones who are in charge of distribution. And publishers like that because then they don't have to worry about it. They've got an entity that they're paying to go ahead and do the distribution. That distribution is costly. And so let me go to the next slide because we're going to talk about that. How much does an author earn per book? If you have a $28 hardcover price and you're getting a 15% royalty, that means that you should be getting $4.20 per book. However, but you see, and how is that calculated? If you look over here, we have hardcover, $28. The publisher only receives 14 because the other 14 is being paid to whoever is printing the book. Okay, let's say it's Ingram Spark. That means that out of that $28, you're only getting 10 to 15% of the publisher's share, which knocks it down to $4.20. Now in an ebook, you'd be getting $2.27. And if you look at the bar grids, you'll see the distributor, this distributor's cut and the production costs are a majority of what the cost of producing a book is. So that's why you see the author's royalty is a tiny sliver of what the publisher is getting. That is the name of the game. And that's why people like to go to self-publishing, because they get 90% of the revenue from Amazon or from whoever does their ebook publishing. Now, one of the benefits, though, of going with a traditional publisher and indie publisher is something that's called an advance. That means that when you sign the contract, they'll give you an upfront amount. It can be anywhere from $1 to $12,000, depending upon what you get. It can be $1 million if you're somebody like the Obamas. Now, what that means is that when you get an advance, you have to earn back that advance through royalties before you see another nickel in royalties from the publisher. So if you look at our example here, let's say that you got an advance of $5,000, okay? $4.20, you got an advance of $5,000, or excuse me, and the book cost, your share is going to be, royalty is going to be $4.20. They have printed 5,000 copies, sold 5,000 copies. So your total revenue and take on this book could be $21,000. However, if you've had a $10,000 advance, you have to earn out $11,000. That means you have to sell copies to earn back more than your advance before you receive another nickel. And what you do is technically every quarter, you're going to be receiving a royalty statement from your publisher, which will give you the number sold of your hardcover, trade, mass market ebook, and audiobooks. I'm going to talk a little bit about that right now. Now, promotion, as far as payments and advances go, one thing that you should keep in mind is that suppose you get royalty statements and you don't understand them. Believe me, they are extremely technical. So you want to have something built into your agreement that allows you to audit your publisher. That means bring your own accountant in, be able to double check their figures. You may not ever want to do it. It might cost you more money to have an accountant go in, but you want to have the right to be able to go to that publisher and say, look, I want to double check your figures. Another question is, who's going to bear the cost for promoting your book to increase sales? Well, most publishers will help you, but 90% of the advertising, 90% of the promotion is on the author. So some people go ahead, they hire outside PR firms, they hire outside marketing. It's things that you do yourself, whether it's a Facebook ad, taking out an ad on Amazon, Goodreads, whatever it is, 90% of the effort is going to be yours. So you have to keep that in mind. And also, the contract should indicate termination clauses. So in other words, what happens if this deal goes south? What happens if the publisher doesn't publish on time? What happens if the publisher rejects your manuscript? What happens if you don't submit your manuscript on time? There are all different kinds of things where breaches could occur by the author, by the publishing company. You want to make sure that you have an out in the event that this relationship does not work. Here are some additional terms that I want you to keep in mind. The right to revise your manuscript. You don't want anything being published under your name that is not your words. you want to go ahead and have the right to revise your manuscript. You want to be able to, if you can't approve, have some kind of input, meaningful input in the cover, the title, and the interior design of your book. As I mentioned, you want to be able to audit to make sure that your royalties are accurate. You want control over editorial changes. You don't want them changing the names of your characters. You want to be able to have a colloquy with your editor and with your publishing company to make sure that what comes out is the best representation of you as an author and them as a publishing house. Also, define out of print. Usually contracts end. Let's say let's say it's a 3 or 4 year contract, or when the book goes out of print. Now today, ebooks live on forever, we know that. So what I suggest generally is that you say, okay, that 25 copies haven't been sold in 2 consecutive quarters. So that means basically the book isn't selling anymore. That allows you to get, the rights back to your book, maybe move on to another company, maybe publish it yourself, but you don't want to be hung up on this out of print because you will never get out of that contract if you do not define what out of print is. Also, in terms of your royalty, what is a net receipt? If it's going to be a royalty that's based upon what the publisher receives, you want to know what the publisher can take out as one of their expenses. What can they deduct from that amount that they're receiving? So I'm going to tell you that writing is a business. So I'm going to give you some do's and don'ts. And these are basic do's and don'ts. First of all, know your goals as an author. Are you thinking long-term? Are you thinking short-term? Are you signing a one-book deal? Are you signing a series deal? What are you signing? What are the terms and conditions and the term of your relationship with the publishing company? Read the entire agreement carefully. Make sure that it's accurate and includes all of the terms and conditions that you've agreed on with your publisher. Because remember, nothing that's oral will be incorporated into that agreement unless it's in writing. They can make you all the promises in the world, but you want it in writing in that agreement. Also, just because you're getting a publishing agreement, don't think you're going to scare them away. Make sure that if there are terms and conditions, such as the ones that I've suggested, that are important to you, that you express that to them, that you revise and you can renegotiate the terms and conditions of that agreement. Because remember, once you sign on the dotted line, you're not able to renegotiate it anymore. So just make sure that by the time that you're signing the contract, or docu-signing the contract these days, that it says everything that you want it to say. And remember to keep it in a safe place. Keep a signed copy in a safe place. With your documents, with your insurance documents, your wills, titles to your car, that type of thing. Oh, and also with your copyrights. Now, do not ever sign an agreement without reviewing it. Get everything in writing. Never assume any terms are agreed upon unless they've been incorporated into the terms of your written contract. And one more do. If you have an agent or you have an attorney, talk to them. Let them review the agreement to make sure that you're getting what you're entitled to. Now, here are some resources that I'd like to pass along to you. First of all, the copyright.gov has a wealth of information, as I said, about copyrights. You can also go to the Patent and Trademark Office. They've got a wealth of information about trademarks and patents. In talking about fair use, if you're interested and you want to look at a little bit more about fair use, you can go to Stanford EDU. They've got a whole school that's dedicated to fair use. The same thing if you're interested in public domain. Duke University Law School, they're in charge of keeping a public domain website. So that's a good place to go. I always tell authors that if they're looking for any resources, go to the Authors Guild. First of all, they've got lawyers there who will review contracts for you for free. They'll set up a website for you for free. They've got all kinds of free videos, archives and programs. I mean, I get emails from them every day telling me about the resources that they have. It's a great, great resource. Also, if you do find that you're in any kind of legal problems, contact the Volunteer Lawyers for the Arts in New York. They'll generally represent you for free. That's their job. And I mean, it's a great organization. I've gone through mediation training with them. They really know what they're doing, and they're thinking about the artists first. And if you're interested in any of the topics that I've covered here, I have done individual blogs on most of them. And you can find it under the Writers Law School tab at my website, jodysusanmillman.com. So this is the end of the program. If you want to stay in touch with me and you want to be eligible to win a really cool prize, you can drop me an email at jodysusanmillman.com and I'll enter you in a drawing. Again, I've got plenty of resources on my website. If you want to follow me, I'm on Goodreads at Jody Millman, Instagram at Jody Writes, and Facebook, Jody Susan Millman. Now, finally, as a lawyer, I have to say to you that the information I provided today is not really designed to be legal advice. It's designed for informational purposes only. And I really hope that you've enjoyed this program. What I'm going to do now is I'm going to sign out of the, and stop sharing my screen, and hopefully we have some time for questions.
Awesome, thank you. That was awesome. I think I already had one question.
Okay. Are you still seeing my screen, or we stopped sharing?
I still see your computer.
Okay, there we go. Okay, there we go. All right.
Okay, so the chat, let's see. Ooh. So there's two questions. I don't know if the first one maybe some of it got answered.
Okay.
And, I'll just say, she said two things. Could you please offer some examples of reasonable book or article contracts? Are there standard templates online? Also, what are items to avoid in such a contract? Thank you.
Okay, first of all, templates are available on the Authors Guild website. And in fact, they have a book that they have posted there, which describes the terms. And really, as you go through the model contract, it tells you what to watch out for. So that is a terrific resource. Again, it's authorsguild.org, and you'll be able to see templates there for model contracts. I hope that answers that question.
That's awesome. That's great. There's another one. Please consider the difference between trade book publishing and academic publishing. Self-publishing is expensive for high quality and could be a nightmare to distribute.
You know, honestly, I do not have any experience in academic publishing. So it's hard for me to give, you know, honestly, for me to give any advice about that. I wish I could.
Okay.
I see another question popped up.
Yes. Does the country that the author live in impact copyright at all?
Yes, it does. Because, for example, if you live in France, you wouldn't be able to get a copyright here in the United States unless your book was published here in the United States. It's not only based upon where the author resides, but where the work is being published. So for example, as I said, copyrights are international, but if I had a UK firm that was publishing it, that would be a different version of the book. They change things. Sometimes they change the title. Sometimes they change words. You'd have to get a separate copyright under the UK statute. So the country does make a difference. Yes, it does.
Thank you. That's awesome. Does anyone else have any questions? There's another one. Are you able to use a line from song lyrics or a sentence from a book or learning program without breaking copyright laws?
Okay, the answer generally is no, you cannot. Because unless you get permission or license from the songwriter or the author. because just as your work is protected by copyright, their work is protected, except we have two exceptions, remember. One, if it's fair use, if you're using it for educational purposes, parody or criticism, or it's in the public domain. So if you're using a line, like the example that I gave was from The Great Gatsby, which went into the public domain this year. You know, better to live than fade away. That could be used because it's no longer subject to copyright protection.
Thank you. Oh, someone's asking about the recording. Will it be sent to participants? What we do, I can ask about it being sent, but I mean, the easiest way is probably in the next couple of days. It's going to be posted on our YouTube channel, and you can get there from going to our website. So I think rather than sending like a video, it might not work that way. You could, if you can't find it from our website, you can go, we can email you just the link to the YouTube page.
And what I'm doing in the chat, I'm putting in my email address. So if anybody wants to enter the drawing, it's jodysusanmillman@gmail.com. You have it. Got it?
It's there, yep. And then I know your website I had, you want me to put that there? Or?
I got it, jodysusanmillman.com. And the reason why Jody Susan Millman instead of Jody Millman was because when, first of all, when I was growing up, people couldn't figure out whether Jody was a boy's name or a girl's name. I'm that old that people didn't know if it was a boy's name or a girl's name. And then when I started practicing law, I wanted the judges to know and the other attorneys to know that I was a female attorney, because at the time it was a very unique thing. There weren't that many women practicing when I started practicing law. So it was a way to distinguish myself. So now it's stuck to me on my forehead. Okay, I see somebody has a question. Does someone have to be paid to be called to work for hire? What if someone volunteers for an organization and gets something published? Generally, if you're doing it, it has to be a term of employment. So let's say you're volunteering and you write a song for some volunteer organization. That, because there's been no consideration, there's been no exchange of money for your artistic work, you would still be the owner. You would really be considered a work for hire. One of the basics is that you have to be paid to be a work for hire.
That's awesome. I think there was probably have time for one more question that I saw right before Anne's. Does registering copyright delay the publisher's registration later on?
Are you talking about, if someone is talking about, in order for a book to be published, they have to get an ISBN number, correct, Christina? That's what really, it follows and scans all the books in commerce. Now, generally a copyright, you can obtain it within 10 minutes. I mean, you go on the copyright website, the form is right there, you fill it out, you pay your $45, you upload it. Just because you don't have the certificate has nothing to do with their ability to get an ISBN number for your book. So that was a long way of saying, no, it shouldn't, because it doesn't take any time to get a copyright.
That makes sense.
There you go. Should you be copywriting your blog? Or is it 9 to publish it? Okay, now, first of all, and let's make this the last question.
Yeah.
If you have published, excuse me, a blog, and it's a series, and you've published it within 3 months of each other, and your blog is 50 words to 1,700 and 17,500 words, you would be entitled to lump them all together and submit one copyright. It's called a group copyright. It's only permitted for literary works. So that is something that I would think, especially if you're blogging about something that's of interest and you have a lot of people that are following you, I would go ahead and do it. But again, the limitation has to be 50 words to 17,500 words. And it's a limit of 50 blogs as well. Okay. So you can mass them all together, pay $65 and send it off for copyright. Maybe you want to tell us what the YouTube channel is, Christina.
Yeah, I'm going to post that right now.
Great. Yes, 17,500 words. 17,500 words. Word limitation on group copyright. Boom.
Thank you. Yeah, so I posted the link. This video probably won't be on there today. I'm just letting you know. Probably Monday. Yeah.
Well, good. I hope everybody enjoyed it. I hope they learned something. And thanks for having me. I appreciate it.
Yeah, this was amazing. Thank you so much. And thanks everyone for coming.
Thank you.
Happy Thanksgiving, everyone.
Bye. Thank you.
Bye-bye now.
Thank you very much.